Commissioner Fielder, can you hear me?
I can hear you.
Morning.
Morning. I am going to step away while I get the rest of my things together.
Okay, thank you.
Pinochi's present.
Good morning, Commissioner Pinochi. I see Commissioner Fielder is on as well.
I'm here. Thank you.
Okay. Good morning. It is now 9:30 a.m. Today's date is April 14, 2022, and it is the time for our regularly scheduled business meeting. Would the other commissioners join me in reciting the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of
To
America
the flag of the United States of America
and to the republic
for
which it stands, one nation, under God, indivisible, with liberty and justice for all.
That may be the most disjointed Pledge of Allegiance we've had at the commission, but the spirit was there. All right, I would note for the record that we do have quorum this morning. Vice President Johnson, Commissioner O'Donnell, and myself are present in the Bollinger Room, and Commissioner Fielder and Commissioner Pinochi are participating via Zoom. We do have quorum. This is a time for our public comment. Is there anybody in the room that would like to make public comment this morning? Saying nobody. Is there anybody online that would like to make public comment this morning? Seeing none, no public comment this morning. There are no changes to the agenda this morning, so we'll move right into our action items. Our first action item is approval of the commission minutes for the week of April 4th, 2022. Is there a motion, Vice President?
Mr. Chair, Mr. President.
All right, is there a second? Commissioner O'Donnell. Discussion, changes to the draft minutes for April 4th, 2022. Seeing none, all those in favor of the Vice President's motion signify by saying aye.
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 All those opposed signify by saying no. Seeing none, the minutes for the week of April 4th, 2022 are adopted as written. That concludes the action items. We'll move into work session item number 1, which is docket 2022.01.010, Northwestern Energy. Northwestern Energy's application for a partial waiver of administrative rule of Montana ARM 38.5176 to discuss Northwestern Energy's request for a partial waiver of the requirement of ARM 38.51.76. Ms. Goldberg.
Good morning, Mr. President and Commissioners. On January 7th, 2022, Northwestern filed a request for partial waiver of ARM 38.5.176. Northwestern is preparing to file an application for authority to increase the rates it charges for natural gas service and electric service in Montana. This filing is subject to the Commission's minimum rate case filing standards, which require Northwestern to prepare and file a marginal cost of service study. In February, the commission publicly noticed Northwestern's request. The deadline for comment has passed and no party has submitted comments in the docket. In recent years, the commission has primarily relied on the results of embedded cost of service analyses to allocate costs and design rates in a natural gas rate case. Northwestern plans to present embedded cost studies for both electric and natural gas and a marginal cost study for electric in the upcoming filing. The commission granted an identical request in the last two natural gas rate cases for MDU. In those matters and in this one, the MCC did not object to the utilities request. Staff recommends approval of Northwestern's request for partial waiver. Thank you.
Thank you, Ms. Colbert. Vice President Johnson.
Thank you, Mr. President. I move that we approve staff recommendation and grant the waiver.
Okay, we have a motion that was seconded by Commissioner O'Donnell. Discussion,
President,
Vice President Johnson.
question, Ms. Gilbert. The rule that we're partially waiving, does it have its foundation in a legislative statutory requirement, or is that simply rule?
Mr. President, Mr. Vice President, I'm not entirely sure, but I could double check for that if it's a rule of our making or if it comes from statute.
Mr. President, my only purpose for that question, if in fact that is simply a matter of our rule and we're routinely waiving it, perhaps we should put on the agenda of things to do a revision of that rule so that we're not going through this process on a regular basis.
You stole my thunder. That was going to be my suggestion as well this morning. Additional discussion,
Mr. President.
Commissioner Fielder.
Yes, I agree with that. If this is being waived frequently, which it seems it has been, that we should just straighten out the rule. And I would just note that we shouldn't, it's unlikely that we would have any rules that are not animals of legislature. We're not supposed to actually. So somehow it's got to be tied to legislation. We'll just have to figure out what the legislation requires and see what we can do to smooth out the process.
Thank you, Commissioner Fielder. Commissioner O'Donnell. Commissioner O'Donnell waves off. Additional discussion? Seeing none, all those in favor of the Vice Chair's motion to approve Northwest Energy's request for a waiver as filed in docket 2022.01.010 signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thanks, Ms. Gilbert.
Mr.
All right, let's-
President,
Yes, Commissioner Fielder.
I just wonder if, I know that the vice chair mentioned it and you and I seem to concur, but can you go ahead and ask staff to begin a rule revision process for that one, or at least examine it?
I think you just made the request.
Well, I did, but I think it has to come from the president, I would suspect.
To the extent that it's needed, then let's go ahead and we'll direct staff to go ahead and look at the possibility of repealing this portion of the rule. All right. Work session item number 2. This is docket 2021.09.118, Northwestern Energy. Petition for purple rulemaking. We're here to get a status update from staff regarding informal rulemaking discussions. Mr. Hamilton.
Yes, thank you, Mr. President and Commissioners. You'll recall that we started a process, an informal rulemaking process in response to Northwestern Energy's petition for purple rulemaking back on February 8th. It's been a little over 2 months now, and I wanted to give you a status update on the progress that we've had in communicating with interested parties about potential revisions to these rules. You'll recall that the first work session that we had on this was a direction to convene an informal roundtable to begin that discussion. We had that roundtable on February 18th, and we recirculated new rules, new red lines of the rules on February 25th, based on the outcome of that discussion. I will say that I think the roundtable was productive. we were able to work through many of the simple cleanup or update revisions that were contemplated in the initial red line that this commission had before it, but did not endorse. Those recirculated rules, again, were circulated on, revised rules, excuse me, were circulated on February 25th. On March 10th, we received Northwestern Energy's red lines. Those are proposals and comments from Northwestern Energy about additional revisions that they would like to request for our purple rules. KELP, QF, responded to those red lines on March 15th. And then on March 16th, staff had a meeting one-on-one with representatives from the UDA law firm to discuss the QF's interests and the QF's proposed revisions to our purple rules. What you have in your meeting materials today is the sum total of what we have received from the parties. That includes Northwestern Energy's red lines and the QF's red lines as the two significant elements of proposed changes for our purple rules. I should note that it did take a little while to get the red lines from the UDA law firm. Those were received just last week on April 7th. Of this year. So at this stage, we have a fairly good set of proposed changes. Some of those raise important legal questions that will need to be sorted out. Some of those legal questions are in fact posed in currently pending dockets, both in front of the commission and in front of the district court, and indeed in front of the Montana Supreme Court. Those concern the interlay or the way that Montana's mini PURPA meshes with the federal law and federal regulations. They concern an ongoing dispute about network upgrades that the commission is well aware of. And of course, some new elements, including Northwestern Energy's proposal to allow curtailment at any time on its discretion, of course, compensated curtailment for any of those circumstances that are not addressed by the uncompensated curtailment provisions of a power purchase agreement. So these have introduced some new legal questions into the purple rulemaking, but we do have, as I mentioned earlier, substantial agreement on a lot of the simple changes, a lot of the important changes that will be necessary to bring our rules up to speed with the current state of FERC's purple rules. We've also received some potentially creative solutions. For example, in the QF's proposal, which we received last week, they included some red line language that would create a mediation process, a sort of early in the docket opportunity for the parties to get together with commission staff to talk through some of the issues in the case and potentially resolve some issues before they even materialize as a contested case issue before the commission. The next steps, from my perspective here, will be for staff to get together and sift through all the various changes that we have received from the parties to propose a staff recommendation of how these rules could be revised. With the current workloads that we have, and as the commission is well aware, the rest of this month is quite busy with hearings. It will likely be May before we have a staff recommendation ready for circulation to the commission. But in the meantime, I would be happy to address any questions that you may have about the materials we've received so far, about our process so far, or about any particular thoughts you may have about the red lines that the parties have submitted. So with that, I would, of course, make myself available here and now to answer any of your questions, but of course, I'm always available down the hall if you have any questions about this going forward.
Thank you, Mr. Hamilton. Any questions for Mr. Hamilton or discussion? Vice President Johnson.
Thank you, Mr. President. There continues to be, Mr. Hamilton, a lot of discussion about and here we go with the acronyms, the ANOPRs and the NOPRs, and nobody's talking about any yuppers, but at any rate, we got a lot going on at that level, that much of which suggests that the very federal rules we're talking about trying to somehow integrate into our system are, through this whole NOPR process, going to be re-reviewed and perhaps re-revised. And so we may well be going through an awful lot of hoops here to put ourselves in a position that is no longer going to be relevant with regard to federal rules. In July, I had a lengthy conversation with FERC Commissioner Christie, explaining to him how the current new rules that we're talking about appeared to provide some relief for us in terms of process and ease some of the regulatory burden we have with regard to PURPA compliance. He indicated to me that he wanted us to send to him an explanation, a commentary defending those rules, explaining why they're important to a commission like us, and which is why we had the conversation about trying to speed up the process of moving them into our rules, et cetera. Question with all of that is, have we done enough that we can at least get a phase one response off to the FERC commissioners saying, this is what we've done, this is why it's important, and we're continuing to work on the rest of it, so that it at least doesn't look like we've simply walked away from this thing?
Mr. President, Mr. Vice President, I think that yes is the short answer. I think that it's always the commission's prerogative to make a comment to the FERC about any particular element of the currently existing FERC rules on PURPA or the whole set of FERC rules on PURPA, to provide support, even if we have not yet proceeded so far in our own process of adopting them in Montana that we can point to the specific rule where it has been carried through the process to Montana's level. I will say that in May, when we have a staff recommendation, I think that would be a good initial timing to submit comments to the FERC, because if the commission agrees with the staff recommendation, or more to the point, if the commission makes a determination about whatever it would like to see in its own PURPA rules, that can be the basis of the first formal notice of proposed rulemaking here in Montana. And that can also be a published document that would serve as the basis for comments to FERC itself. Again, I think that the current workload through the rest of this month is going to be difficult. But come May, I think that we would be in a good position to provide that sort of staff support.
Mr. President,
Follow up.
I would like, even if it's informally, Mr. President, see us, and I understand how much y'all have on your plate, and if we need to push this into May, that's it is, and these other things take precedent. There's no question about that. But Mr. President, I would like to at least informally direct staff to prepare comment to FERC that relates to them, what we're doing to try and incorporate these rules into ours, and some commentary with regard to how we believe the rules as currently revised would provide some regulatory relief to our dealing with PURPA compliance. If that's, Mr. Hamilton, isn't just an overly onerous burden given some additional time.
Mr. President, Mr. Vice President, we can take that informal direction. I would, of course, defer to my supervisor and maybe his supervisor as well to assign the staff resources to the task, but we will absolutely take that direction.
Commissioner Fielder.
Thank you, Mr. President. So just regarding the creative idea that was put forward by one of the parties regarding the early resolution of matters, that on its face sounds good. I mean, anytime you can see resolution early and avoid long contested, drawn out procedures that may very well result in the same outcome, I would say that would be helpful to get that streamlined. But I also would ask staff to just advise us if staff decides that and recommends that as part of the adoption to these rules. I'd like to see the pros and cons of that aspect in particular, because sometimes two parties can get together and negotiate in their own best interest, but other factors aren't part of the equation. And I think it's important that we take a broad view to these types of decisions in terms of setting any kind of precedent or anything like that may affect other cases or other outcomes, or even the outcome of this case or the particular case, whether it's in the best interest of both the people that we serve and the utilities that we regulate.
Mr. Hamilton, did you want to comment on that?
If I could, just very briefly here, Mr. President, Commissioner Fielder, absolutely, we will take that into account. We will be sure to include a robust analysis of that particular proposal of the sort of early mediation in any staff recommendation that would follow this process. I would note, however, that we are in a unique circumstance legally here with our implementation of PURPA in Montana, especially following some of the recent Montana Supreme Court cases. The MT Sun case in particular discussed how this commission lacks the authority to replace the negotiated terms of a contract between the utility and the QF, that we cannot insert ourselves in that process and deprive them of the benefit of that negotiated agreement that they arrived at before they came to us. So to the extent that they do have a term in their contract, either initially undisputed or initially disputed that is then resolved through mediation, that would enter a realm that is, at least under MT Sun's precedent, arguably beyond the commission's jurisdiction to change. That becomes a fixed element of the contract.
Mr. President.
Follow up?
Yes, well, thank you for that response, Mr. Hamilton. Given the magnitude of the impact on ratepayers for these negotiated contracts, I think we need to be very, very cautious and careful with what we end up deciding here, because I mean, I was just reviewing the terms that were set forth when Montana Power was acquired by Northwestern Energy, and that was just shy of $700 million involved in some contracts that were in place that had to be passed on to the ratepayer above and beyond, as I understand it, above and beyond the actual cost for producing the energy. So, I mean, the value of the energy. So I just think we should be very, very careful with this, because as I look back at those contracts that were negotiated and agreed to back in the 80s and 90s, and ratepayers are still paying for those added costs, at a rate of about $26 million per year, every single year for the next, until 2029, if I understand it right. So big implications on these things.
Commissioner O'Donnell?
Thank you. Three things. One, to add to and echo the Vice President's comments, FERC Commissioner Danley also at more than one meeting that I was in attendance, practically begged states to communicate with FERC. I mean, they're really, really interested in these things. Number two, in terms of the informal possible reconciliation of differences in informal basis, I agree with Commissioner Fielder that I don't know how attorneys thrash things out on an informal basis, but on the formal basis, the public basis, it takes forever. It is especially tiresome to those of us who were in the arena watching all of this sparring happen. So that might be very productive in that regard. The other one is, I wanted to express my appreciation in discussions with you, Mr. Hamilton, about this, that I appreciate the staff's sensitivity to reconciling the different comments by the different parties to these things, is that your particular appreciation that some of these comments by different parties are perhaps subtle but significant in terms of entering terms or conditions that are beneficial to themselves and maybe not the other parties. So I really appreciate your attitude toward the whole thing, and all other staff that are involved in it. But I'm looking forward to the reconciliation of all these different comments. Thank you.
Okay. Additional comment? Okay, seeing none. Thank you, Mr. Hamilton. Okay, let's move to work session item number 3, which is docket 2021.09.111 Northwestern Energy. We're here on Northwestern Energy's request for approval to revise qualifying facility power purchase tariff schedule QF1. to consider motions for reconsideration filed by MCC and Northwestern. Mr. Hamilton.
Thank you again, Mr. President. Commissioners, before you, you have two motions for reconsideration filed by Northwestern Energy and the Montana Consumer Council. Northwestern Energy requests a reversal of the disposition, which was to dismiss the filing, and for the striking of paragraphs 10 through 15, excuse me, of the commission's prior order on this as legally and factually incorrect dicta. Dicta being language that's not really binding, it's explanatory on top, above and beyond what is necessary to resolve the case. MCC, for their part, also requested that the commission strike those paragraphs of the prior order in this docket. Before you, you have a staff memo and a draft order on reconsideration for your consideration. Both of those documents describe sort of staff's analysis of this, which results in the recommendation that the disposition remain the same, that the filing be dismissed. Of course, the order on reconsideration still reiterates that Northwestern Energy is free to file an application for revision of the standard rate tariff, the QF1 tariff. But critical to staff's analysis here, the application under our rules contemplates the commission would consider current avoided cost data, both from the utility and from other interested parties. And that is an element that is currently missing in the filings submitted by Northwestern Energy. So for that reason, staff recommends that the commission not consider it an application under our rules. An application would involve a full vetting of the facts and a full argument, which this commission is well aware of in QF cases is a fairly long and drawn out process. But that would result in a new application and a new QF1 rate tariff. So with that, staff's recommendation is to grant in part the request to strike paragraphs 10 through 15 of the prior order as dicta, unnecessary for the disposition of this case, but to maintain the disposition by issuing the draft order on reconsideration before you.
All right, so I'm going to move to consider both MCC's and Northwestern Energy's reconsideration as one motion. So I'm going to recommend the commission affirm in part and grant in part. So I'm going to recommend that the commission affirm its decision to dismiss this docket as we have previously determined. However, to grant in part that portion of the reconsideration to strike paragraphs 10 through 15 of the commission's orders 7815F as it is dicta. Is there a second?
I have a question first.
Mhm.
Wouldn't it be simpler to deny Northwestern's application and approve MCC's instead of affirming that part of Northwestern's application, which agrees with what MCC was asking for? Wouldn't it just be simpler that way? It just seems like it to me.
Mr. Hamilton?
Mr. President, Commissioner O'Donnell, I think that might actually make things more complicated in denying Northwestern's request to strike those paragraphs. We would have to establish a reason for denying that element of Northwestern's request, but then granting the same request in the context of MCC's motion.
Thank you.
Mr. President, I also have a question.
Commissioner Fielder?
Thank you.
By the way, these questions aren't even germane because we don't have a second on my motion, but
Well, it's a point of order question for me, Mr.
right.
President. So I would like to act on these separately and individually. So I would, because I'm going to vote one way on one part of it, another way on another part. So would it be in order to wait until you get a second to your motion and then for me to move to segregate them so we can take them up individually?
that would be procedurally correct.
Okay, then I will second your motion for that purpose, and then I'd like to move to segregate Northwestern Energy's motion, the two parts of it, and deal with each part of Northwestern's motion and also deal with MCC's motion. So those three motions are separated, segregated.
Okay, so so you're moving to segregate our consideration of each of the motions for reconsideration, correct?
What I'm trying to do, Mr. President, is to be able to vote on the two motions that deal with removing the paragraphs. And then, and to not to create the problems that Mr. Hamilton described, to be able to vote on each of those. And then to also be able to vote separately on the reconsideration of our decision that had dismissed the docket without prejudice. If you recall, that was a not a unanimous decision. I was a dissenting vote on that, and I'd like to maintain my dissension on that decision. But I don't intend to dissent to removing the paragraphs, if you understand.
Is there a second for the motion for segregation?
Really?
So, seeing none.
Okay.
Motion fails for want of a second. All right, we're back to the underlying motion. Discussion. Mr. Fielder.
Well, Mr. Chairman, my colleagues have put me in the position of having to vote no on it. Even though I support 2/3 of the motion, I have to vote no on it because I disagree with one part of it. So I'm disappointed that my colleagues did not allow me to make separate votes on the record for my, that demonstrate my reasoning.
Additional discussion? Commissioner O'Donnell? Well, I just wanted to say I'm sensitive to Commissioner Fielder's feelings. I simply don't understand why, and I didn't second it because I didn't see why her motion would be any different from the president's motion to accomplish all of that. Apparently it's important to Commissioner Fielder, but I didn't grasp the reasoning behind that. But I would like to ask Mr. Hamilton, based upon his response to my point, does this make anything simpler or more difficult or what?
Mr. President, Commissioner O'Donnell, I think maybe one way that we could address this that the commission has used in the past is to have an additional statement at the end of the order from the dissenting vote that could dissent in part and only in part, I suppose, to the disposition of this order if the commission decides to adopt staff recommendations. So we could, I guess, Commissioner Fielder, include that additional language to explain your position.
I would agree with Mr. Hamilton. I think that's the most effective way of disposing of Commissioner Fielder's concerns and position in this matter. Additional discussion? Seeing none, all those in favor of my motion signify by saying aye.
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 All those opposed signify by saying no.
No.
Let the record reflect that 4 commissioners voted aye and Commissioner Fielder dissented, but will provide a written statement that she concurs with part of the motion. Okay. Thank you, Mr. Hamilton. All right, let's move to work session item number 4. This is docket 2021.09.121. This is Moonlight Basin Water and Sewer LLC application of Moonlight Basin Water and Sewer LLC for authority to increase rates pursuant to the commission's operating ratio methodology. We're here to make a final decision on the proposed application. Mr. Fink.
Good morning, President, Commissioners. On September 29th, 2021, the Commission received the application for MT Moonlight Basin Water and Sewer for revised rates. This utility is located in Big Sky, Montana. As President mentioned, utility used the operating ratio methodology to calculate a rate increase of $5.91 per single family equivalent, which considers unit size and estimated usage based on the number of bedrooms and bathrooms. Moonlight Basin also requested to establish sprinkler restriction violation fees with this docket or its application. Moonlight Basin has 349 residential customers, 7 commercial customers, and 28 custom home lots for its combined water and sewer rate. This amounts to 790 single-family equivalents. The Montana Consumer Council petitioned to intervene on December 20th, 2021, and their petition was subsequently granted. Both the Commission and Montana Consumer Council submitted data requests. While reviewing those data responses, there was an error found in Moonlight Basin's application, at which point Moonlight Basin was contacted informally by the Montana Consumer Council. And soon thereafter, Moonlight Basin requested to extend the additional process date. Sometime after that, Moonlight Basin filed an amendment to its application to resolve this error that was found. To point out the error, they inadvertently omitted its commercial as single family equivalent. And so they included that with their amendment. After that, no party requested additional process in this matter. And staff is available for questions and discussion.
Do you want to win? Wave off. All right. Commissioner O'Donnell.
Thank you. So in reading this, MCC discovered that the commercial users weren't included in this. Is that the result of the difference between their initial request of 1498 increase and then the 591? Is after bringing in the commercial customers, is it still the same? Didn't change the ORM in any way. It's basically the same thing.
President Commissioner O'Donnell, that's correct. Its revenue requirement does not change. It did change their total single family equivalents, which is going to change their per dollar amount increase per single family equivalent, which is what you pointed out.
Very good. Thank you.
Vice President Johnson. Would you like to make a motion?
I'm sorry, I guess I thought we had one. I move we approve staff recommendation. Docket, pardon me.
All right, so we have a motion and a second discussion. Commissioner Fielder.
Thank you, Mr. President. Just a procedural question, perhaps for my own edification. So when the application is amended by the party, is it considered amended, or is this motion to accept that amendment to the application?
Mr. Finger.
President Brown, Commissioner Fielder, when a party makes an amendment to their application, and my, I guess, knowledge here at the commission, it's an additional information included with that application. And so I don't believe that there is any additional process involved with the procedural dates with that application. If that answers your question.
Commissioner Fielder.
Okay, so I'm hearing that the party can go ahead and amend its application without any action by us. So the motion is just a clean motion to accept their application as amended.
That's
That's-
my
okay.
understanding, Commissioner Fielder.
Thank you.
Is that correct?
President Brown, Commissioner Fielder, that's correct as far as I'm concerned. Yes, that's how the process.
Okay. Additional discussion? Seeing none, all those in favor of the Vice President's motion signify by saying aye.
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 All those opposed signify by saying no. Motion carries unanimously. Thank you. All right, let's move to work session. Item number 5. This is commission initiated. This is litigation status update. Commission will meet to provide an update, to receive an update on currently pending litigation and to discuss litigation strategy. This portion will be closed to the public. So with that being said, I would note for the record that the presiding officer of any meeting may close the meeting during the time discussion relates to a matter of litigation and or litigation strategy. And the presiding officer, which is me in this case, determines the need to protect agency litigation decision-making, and the discussion exceeds the merits of public disclosure. The discussion that will be had in this closed session will involve discussions and decision-making related to ongoing litigation in which the agency is involved as a party. Accordingly, as the presiding officer of this meeting, I am closing the upcoming portion of the meeting to the public. Upon conclusion of our closed portion of our meeting, we will adjourn the business meeting.
Mr. President,
Yes, Commissioner Fielder.
I don't think we've received a link, a remote link for this section of the closed section of the meeting yet. So if we could have staff get us something, that'd be great. They did check with me this morning to make sure I had everything, and I thought I did, but I just didn't have this link.
Okay, I am being informed by staff that it's the same link as the scheduling meeting from this morning. Mr.
Okay,
Reed, you want to add
terrific.
anything?
Yes, President Brown, Commissioner Fielder, part of the reason that we don't send the documents out is the same reason that we have a closed session. We would, the litigation session is not likely to involve dissemination of new documents or documents that the commissioners have not already seen.
Thank you, Mr. President. My question's just about access to the meeting. That's all.
Okay, Commissioner Pinochi, did you get that as well?
I did. Thank you.
Okay, we'll reconvene, I would say, and why don't we give it 10 minutes, 10:20? Okay, thank you.